So you've got an issue with your HOA. Maybe it's a fine you think is unfair, a denied architectural request, or a neighbor who's breaking the rules with no consequences. Whatever it is, that feeling of frustration can be overwhelming. Thank you so much for watching. If you found this helpful, please give this video a thumbs up, and don't forget to subscribe for more tips on navigating life in an HOA. Let me know in the comments if you've ever used your HOA documents to successfully resolve a dispute. Before you fire off an angry email or start a neighborhood war, take a deep breath. The first, most critical step in resolving any dispute with your homeowners association is something surprisingly simple. Read your governing documents. I know. It sounds about as exciting as watching paint dry. These documents, often called the CC&Rs, for covenants, conditions, and restrictions, along with the bylaws and other rules, can be thick, dense, and full of legal jargon. But trust me, this is your secret weapon. Your HOA isn't some all-powerful entity that can do whatever it wants. It's a corporation, and its power is strictly defined and limited by these very documents. They are the rule book for the entire community, including for the board members themselves. Think of it like a game. You can't win if you don't know the rules, right? Well, your HOA's governing documents are the official rulebook. They lay out everything. What you can and can't do with your property, what the HOA is responsible for, and most importantly for our topic today, the exact procedures for how disputes are supposed to be handled. Ignoring these documents is like trying to play chess without knowing how the pieces move. You're setting yourself up for failure. So, where do you start? First, get a copy of all the governing documents. If you didn't receive them when you bought your home, you have a right to them. The HOA is legally obligated to provide them, though they might charge a small fee for copying. Check the HOA's website first. Many now have digital copies available for download, which is super convenient. Once you have them, grab a highlighter and a cup of coffee. You're going on a treasure hunt. You're looking for specific sections. First, find the rule that's at the heart of your dispute. If you've got a fine for your trash cans being out too long, find the exact section that details the trash can rules. See what it says. Is it specific about the time, the day, the location? Sometimes, you'll find the rule is vaguer than the violation notice suggests, which could be a point in your favor. Or you might find the board is misinterpreting their own rule. Next, and this is the really crucial part, look for sections titled Dispute Resolution, Enforcement, Violations, or Hearings. This is the playbook. It will tell you the step-by-step process the HOA must follow. It will answer questions like, do they have to send a warning letter before issuing a fine? Are you entitled to a hearing with the board? How much notice do they have to give you for that hearing? Can you bring evidence or witnesses? This is where so many homeowners go wrong. They skip this step and just complain, but they don't follow the official process. And guess what? If you don't follow the process outlined in the documents, the board can often dismiss your complaint on a technicality, regardless of whether you're right or wrong. You have to follow the procedure. Let's walk through a common scenario. Say you get a notice that you need to repaint your front door because it's a non-approved color. Your first instinct might be to argue that the color looks fine, but a better approach is to check the documents. Find the architectural guidelines. Does it list approved colors? If so, is your color on the list or not? If it's not, you might have to repaint. But what if the rule just says earth tones and you believe your color qualifies? Now you have a basis for an appeal. Next, you look up the dispute resolution process. It probably says you must submit a written appeal within, say, 15 days. It might specify that you need to request a hearing with the board. So, you draft a formal, polite letter. You state your case clearly. Dear board, I am writing to appeal the notice regarding my front door color, dated October 26th. Per Section 8.2 of the Architectural Guidelines, which states that doors must be earth tones, I believe my color, forest moss, fits this description. I respectfully request a hearing to discuss this matter as outlined in the bylaws. Section 12.4. See how powerful that is. You're not just complaining. You're citing their own rules back at them. You re-showing them that you've done your homework and that you intend to follow the established procedure. This immediately changes the dynamic. It moves you from being seen as a problem resident to a well-informed homeowner who is simply exercising their rights according to the agreed-upon rules. Board members, who are often volunteers, are more likely to take you seriously when you approach the situation professionally and with evidence from the documents. Knowing the rules also protects you from an overreaching board. Sometimes, a board might try to enforce a rule that doesn't actually exist in the documents, or they might skip steps in the enforcement process, like fining you without a required warning. If you know the procedure, you can call them on it. In your appeal, you can politely point out, per the enforcement procedure, a written warning is required before a fine can be levied. As I did not receive one, I request this fine be rescinded. This is much more effective than just saying, it's not fair. Beyond the formal CC&Rs and bylaws, also look for the meeting minutes from past HOA board meetings. These are also part of the official records and you have a right to access them. Reading the minutes can give you incredible insight. You can see how the board has handled similar issues in the past. Did they grant an exception for someone else in a similar situation? That's called precedent, and you can use it in your favor. You might also discover if the rule you're in conflict with was recently discussed or changed, which can provide important context. Remember to always communicate in writing. Emails are good. Certified mail is even better for really serious issues. This creates a paper trail. If you have a phone call or a face-to-face conversation with a board member, send a follow-up email summarizing what was discussed. Dear John, thank you for speaking with me today. Just to confirm, you said the board would review my request at the next meeting on November 15th. This prevents, he said, she said, confusion later on. If you go through the entire internal dispute process outlined in your documents and you still do get a fair resolution, that's when you might consider other options, like mediation or even legal action. But even then, the very first thing an attorney will ask you for is a copy of your governing documents and the paper trail of your attempts to resolve the issue internally. Without that, they can't help you. So, to wrap it all up, your HOA's governing documents are not your enemy. They are your guide. They are the single most powerful tool you have. Reading them is the non-negotiable first step. It allows you to understand your rights and obligations. Follow the correct procedure, communicate effectively, and hold your HOA accountable to the very rules they are supposed to enforce. It takes a little bit of effort up front, but it can save you an immense amount of time, money, and stress in the long run.